Everybody, and welcome to Patriots Law Group Live. This is all about legal strategies for navigating your military divorce. We come in every other week, and this is a wonderful event in which we bring you different topics to help you navigate your military divorce. So whether you're active duty, you're a veteran, or even if you're a military spouse, this is the place to be to help you navigate one of the most difficult times. And today we have a topic of how avoid the 5 top pitfalls that happen early on in a military divorce. And so we have some legal strategies to help you with that. And of course, we have our 2 hosts that are amazing. We have Patrick Hughes, goes by Pat, and we have Michael Lyons. Mike, I want to welcome both of you back to provide your expertise in this particular topic. So welcome back, guys.
Hey,
good to be back. Yeah, thanks.
And Pat, we missed you a couple of weeks ago. I said you were on vacation, but I hear you were actually doing some military duty. So that was probably more important than being on vacation, right?
It's all the same, right, Pat?
Yeah, right. Some people think that.
So this is a really important topic, and we always like to do things in 5s because, I think it's easy for us to digest things in 5s. And so everybody, I say, get a pencil, get a piece of paper, take a few notes out there, because when we talk about pitfalls, especially early on in a divorce, these are things that, get on paper so that you can take to an attorney if you've already hired one, or if you need to reach out to Mike and Pat, you at least have some information in front of you that you've picked up today that you can familiarize yourself with and remember. So let's dive into the first one. Mike, Pat, which one of you would like to take our very first pitfall?
Yeah, I'll jump in there. This is really the first step in every case. We've addressed it a couple different times as it relates to pensions, but filing in the wrong state. It's stepping on filing in the wrong state. The wrong foot if you're in the wrong state. Where this comes up, again, we've mentioned it with pensions before, but I'll address now custody. Can see it quite frequently where people will file in a state that they presently live in without considering the various laws and rules concerning jurisdiction for child custody, which generally is where the child's lived for 6 months. So, some clients will come in having moved a week or so ago to Maryland and file a custody case and don't realize that before moving, they lived 2 years in Oklahoma. Well, the law says Oklahoma is the right place to file, not Maryland. So before you file, run to ground what state, at least for child custody purposes, but a lot of other reasons too, you should be filing in. Tip number 1.
Awesome. Very important advice. They may think that where they're standing right at that moment may be the right state, and it's not. Great advice. So everybody write that one down. All right. So
yeah, well, just to follow up, Maureen, if I could follow up on that too, because I've used this for service members or against service members. A military member's pension can only be divided by the state in which they're domiciled unless the service member consents to that jurisdiction. And that goes back to something that we had said a couple times ago, I guess a couple LinkedIns ago, where lawyers might file in the wrong jurisdiction. You've wasted all that time and money in that particular jurisdiction because of this defense that exists. It not only is it time, but it's a lot of money that's involved if somebody files in the wrong state. So just to kind of add on to that, it's something that you need to make sure that your attorney knows what they're doing when it comes to a military member's situation.
Yeah, it's like, what do they say? A stitch in time saves 9. that old saying. It's one of those things for sure.
Yeah. Now, a second thing that we're wanting to make sure people were aware of is because we see this time and time again, agree to support determination without getting the entitlements calculated in some meaningful and corroborating way. Sometimes, the spouses leading into their divorce will negotiate things on their own without making any effort to calculate the entitlements that might be involved. And then lo and behold, later in time, had that one spouse known that certain entitlements existed for them, they would have gotten a lot more than what they had agreed to. And so there's certain tactics or efforts that can be taken in a proceeding, like it's called a pendente lite hearing, where it's just basically an interim decision on some support for spousal support or child support or things like that do involve the ability to discover and know and use state guidelines as calculations to determine what someone should be receiving, either in the interim, like that pendente lite, but then at the end, as a final decision for the custody or divorce proceedings, the court will issue a ruling, and that will be based on a lot of the corroborating evidence to know what's out there and what should be divided and what should be serving as income for a support determination. So it's important to not just handshake a deal with someone without knowing the full extent of what is out there and calculating what would be required under the state's guidelines, because it's really a formula. It's a plug and chug. And if people don't know that formula is out there and don't know what information should be used to calculate the formula, then oftentimes they'll end up shortchanging themselves.
So I have a question about that. If it's only a handshake between the two of them, though, is that really a valid contract? They could say, oh, well, we could just kind of, talked about it ourselves. He told me I was getting this. She told me I was getting that. But nothing legally was signed. So we're starting over, right?
Yeah. Here, I'll chime in here.
Yeah.
My answer may be yes and maybe no. I mean, the courts can consider if an agreement's been made. Most of the time, our service members, because they have legal assistants that can help them draft an agreement, will in fact do it by agreement because they have just enough legal services to make it binding. And the what they walk in with as their agreement may not be informed, I think, as Pat said. And I've seen it cut the other way, which is somebody agrees to pay way too much. Maybe they feel bad about the way the circumstances are ending, or maybe they say, I'll pay all of these expenses, put it in an agreement thinking, well, we're going to sell the house at some point, only to find out that the other side's not intending to sell the house and a divorce is 1.5 years away and they're now on the hook for all of that. So yeah, Pat hits the nail on the head there for sure. And there's calculators online for child support, so it can be found out. Legal assistance attorneys can definitely help out with those calculations, but you got to know it.
Yeah, and I'll add to that too. There's also, like, by regulation, there are certain requirements for a service member to have to support their dependents financially, and adequate financial support is basically the default using the regulation, absent a court order or an agreement between the parties, and oftentimes people may not be aware of that as well. And a service member has an obligation to support his or her dependents by the fact that they're getting more because they exist. And so if someone who's not in the military who's initiating a divorce proceeding may or may not be aware of that, or the attorney representing them may or not be aware of that. And this is all, even if an agreement isn't in existence or a court order isn't in existence, there's still an obligation of that service member to have to adequately support his or her dependents.
And I think we go back to why military divorce specialists are so important here. People who kind of know the nitty gritty, ins and outs of this, where many civilian attorneys may not know because they really don't kind of specialize, in these nuances. And that's what we're, trying to really get that point across to people out there, that there really is a difference here. People who really are laser focused in this and specialize in this can pick up on these things early on, these early pitfalls that could happen. So, we want to make that clear out there, that this is a different type of divorce, All right. So number 3.
Yeah. Number 3. This is one, and I think there's some of the unique nature of being a spouse to a service member is what drives this. But tip number 3 is don't mediate. Don't even go to mediation unless you get full disclosure of the financial picture. That's you disclosing what you have and the other disclosing what they have. And the reason why I say I think probably the unique circumstance of a military spouse continually stopping their jobs, picking up their residences, and moving from duty location to duty location is, I think, drives them to say, when a marriage is ending, I just want to end it and get back to my support system, to get back to, where I feel comfortable and safe and able to pick up and move on. So say if they're here in Maryland because this is their latest duty station, and before that they were in Florida, in San Diego, and maybe over in Germany, and now the marriage is ending, and one party comes and says, hey, I'll pay for it. I hear this seems to be frequently. I'll give you my GI Bill. I'll give you $10,000 and I'll pay the car note. And then you can move back in with your mom back in Washington while we go forward with this divorce. But I want you to sign this settlement agreement that says that, or I want to mediate effectively those terms, and no financials are put on the table. It's just talked about in these types of strokes. What do I need now? And the vulnerability of the former or of the spouse in that they don't have a job here. And if they're not living with the service member, they don't have a reason to be here in Maryland, I think makes them particularly vulnerable to saying, yes, I'll walk into mediation a week after we decided we're going to get divorced, without any awareness of the financial picture and what I may be entitled to, either in the divorce or in a TSP or even in equitable relief like alimony or something like that, or use of the marital home. So I think one of the worst pitfalls I see are people thinking they're doing a good thing by working towards an amicable resolution in mediation, but not knowing what's at stake, and then coming out of it with less than they should have received. And sometimes feeling a little railroaded into the mediation because it's presented as a take it or leave it. Go to mediation and we'll give you we'll work this out amicably, or it's going to be scorched earth and I have the resources and you don't, so you know what that's going to look like. But the law is designed to be fair, to be equitable. So that really is a not an accurate description of the service, or excuse me, of the spouse's rights. Take it or leave it isn't really true. So get those financial documents. If you do want to quickly divorce and you do want to go to mediation, just do it right. Don't do it quick.
Yep.
Good advice. Good advice. I think people try and rush this through because it is painful. They just want it over and move on.
Right. Yes.
All right.
And unfortunately, in many states, Virginia is one of them for sure. You can't rush into it, regardless of what you hope you want. There's a cooling off period that a fair number of states require before you can get things accomplished. And the process, just generally, a court's system is not designed to have a signature stroked by a judge in a week from when you made a decision that you want something to happen. So there's really no need to rush into these things when getting the right information is so critical to resolving things amicably.
Well, I know in Maryland, you have to separate for 6 months before you can even move forward with a divorce. Now, separation, I don't know if that necessarily means you both get your own apartment, but I think you have to file a separation and say this was our separation date before they'll ever allow you to move forward. I don't know if that's still the case, but
it kind of depends on the grounds that you're relying on, I suppose. Sorry, Mike, didn't mean to step over you.
Well, I was going to mention, Maureen, the law in this area is very rapidly changing, and it has changed now. And it really lends itself to that sort of urge to be done, because in Maryland, you can immediately get a divorce if you have a settlement agreement that resolves everything. So, again, if you're somebody that's in a foreign area or foreign state from where your whole support network is, and you can quickly get something and get back to your hometown and the safety and security of your family and your, friends, you might be very tempted to execute a document that fully resolves all the issues. And if you do it without knowing what was really in play as far as the financial assets, you more likely than not are going to be disappointed, because people just simply don't. They either give you exactly what you deserve or less, right? So you're at the mercy of, is your spouse the type that's going to give you half and disclose everything to you? If so, why not ask for it? They won't mind. If they're the type of spouse, though, that isn't so interested in giving you half, and you ask them and they say, take it or leave it, then you know what? There's a big red flag. And get somebody that knows what they're doing, because there is something on the table. That's the only reason they wouldn't show you, is because they want to have something left on the table.
Right.
You ready for number 4, Maureen?
We are, but I do want to let everybody out there know that, before we move into each one of our top 5, if you do have a question, go ahead and, post it in the comments. This is for engagement. If you find there's a question on any one of these as you're taking notes, or something comes up and you want to ask Mike or Pat to elaborate on something, or even if you have a different question, this is all about your opportunity to, ask questions. And of course, we can do it at the end as well. So I want people to understand that this is also your time to get your questions answered. So yes, we can move to number 4, but I do want people to be aware of that. So let's jump into that.
Mike and I love a hot bench. They call it.
Absolutely.
The judge sits on the bench. So I have to be a little careful when I raise this issue, because there's certainly some caution that needs to be involved in fully contemplating the circumstances. But one is not to seek a protective order unless you absolutely need one. And tips is not to seek and what we mean by that is we occasionally see a circumstance where, under the facts and circumstances presented, it might be pretty unlikely that a protective order would even be granted. Say person has moved to the state of Washington and the service member remains in the DC area. Like, there's a lot of distance between the two of those people. Is it likely that there's any imminent danger? If an event that someone is relying on to say that they were abused occurred 9 months ago and things have been entirely okay since then, they've been living together and there's been no incident, is something that happened 9 months ago going to be enough to support that a protective order should be granted by a judge? And so the reason why someone needs to tread with caution to pursue a protective order, and certainly if they are truly in imminent danger, that may be the right approach to take, is to pursue a protective order. In the end, also, unfortunately, at times it's just a piece of paper. It doesn't say that someone is not going to come after you just because you've obtained a protective order. Certainly it provides some recourse if that were to happen, if someone were to encroach upon the order that was issued in that protective order. But you need to give full thought to whether it's worth pursuing. And I say that because there's kind of a couple of different perspectives to look at it from. First off, if a non-military spouse is seeking a protective order against someone that that is going to potentially lead to some really serious ramifications for that service member, it implicates, if it's granted, it implicates the Lautenberg Act, and then means that someone might not be able to possess a weapon, which is something that service members often need to do to be able to perform their job. It also may implicate that person's security clearance. It may lead to Uniform Code of Military Justice disciplinary action. And all of those second and third order effects may end up actually impacting the non-military spouse's ability to the entitlements and benefits that might have flowed to that person because of the service member's, employment and, what would be transferable to a non-military spouse at the time of divorce, or what would be continued support, like the basic allowance for housing and other things. Like if the service member loses his or her job, then those types of entitlements that could have flowed to the non-military spouse may be taken away from them as a result of what started out to be the initiation of a protective order. And then also from a different perspective, if there's not a likelihood of the protective order being granted based on the facts and circumstances as determined by the advice of an attorney who knows what they're talking about, if you go into that courtroom and then all of a sudden the judge denies it, it could end up being used as leverage by the opposing party to say that the person is just trying to game the system to establish leverage or improve their possibility of child custody and so forth. And so it could end up backfiring on someone if they don't really have a decent case to pursue, and they end up pursuing it, and then that may end up backfiring. So there are ways that someone can go about getting the types of protections that they seek from a protective order in a family court, family law, domestic, case, like that they've initiated the divorce proceedings, and the court in this pendente lite decision or otherwise might be able to establish certain things in an order from that court in the family law case that would still account for and in many ways mirror what the protective order could have done, like use and possession of a home, saying that someone has to move out, saying that there be no contact with the spouse except through attorneys, or other things that can be baked into an order that will get the type of outcome that a protective order could have provided in many ways, but still not actually end up implicating all of these second and third order effects, because a protective order would have the implication of a Lautenberg or security clearance impact, whereas a family law court order wouldn't implicate those things, but could still accomplish many of the things that someone might intend had they gone through a protective order. So again, just to re-raise that caution, if there's truly an imminent harm that's someone's really concerned about, a protective order might be the right approach, but it's just something that you should tread cautiously in doing, and talking through with your attorney about whether that's the right strategy and approach to take.
Wow. That is amazing advice. I kind of knew where you were going with that, but I think that people do have to balance those decisions, especially on the income side. They may not realize the long-term ramifications of supporting their children, supporting their livelihood, and the long-term, opportunities for that spouse, that ex-spouse, to be able to make an income to help them. So huge decision. So that was really good. Really, really good. So Mike, what's the fifth one? And I know two questions came in that I'd love to get to. So what is our fifth one?
Yeah. Well, the fifth one's pretty pretty straightforward. Don't use emotional or abusive language when this whole thing's kicking off. I mean, it's the classic mistake. And then if you do use it and you do it in writing, all you've done is manufactured evidence, right, for the case against you. And so, you know, if somebody on the other side is sending you this emotional and abusive text or email, say, yes, I have evidence, and then say, double yes, I'm going to make evidence that makes me look good, and respond to the particular issue and ignore the interpersonal attack levied on you and taking the high ground. It may be hard to do. You may not feel great about sort of taking it, but at the end of the day, 9 months from or 12 months from when the case gets started, a judge is going to be looking at everything and saying, who's the mature parent, and who's the one that sort of can't be trusted and can be trusted. And so, best tip I can give you, and the tip that I give every client that I have that's involved in a custody case, is do everything in writing, nothing verbally, and do everything like you're talking to, you know, your boss or your grandmother, maybe not your parent, your grandparent, right? And you're going to come off looking great. So tip number 5, avoid using any abusive or emotional language, particularly in writing, when you're involved in a custody case.
It's great.
Yeah, that might be a circumstance where if you're in a volatile situation like that, not every case is like that. People are often, you know, amenable to, it didn't work out and we're ready to separate and divorce. But I mean, if it's volatile, then you may want to rely on exchanges between your attorneys to avoid even jumping into an emotional circumstance where that could end up blowing back on someone. I personally like to involve the lawyers the least amount possible, because it saves our clients money. And if they're getting along and you know, there's certain things that you definitely want to involve your lawyer in, but if there's decisions that really are between the divorcing parents of a child custody situation or other reasons, then if people can work it out on their own where there's not high volatile emotion involved, then I'm okay with that personally, to step aside and let the clients figure that out. But in another circumstance where it's just high emotion, then involving the lawyers more at that point might be the wise choice.
Yeah.
And let's talk about, divorce is one of the highest emotions that people have and going through. So you have to lower the temperature a lot of the times here for everybody's best interest. So, oh my gosh, great tips. 5 amazing tips here. All right, so let's have a question. We have time for one question. I think we talked a little bit about this, but a question's come in from Cassandra. What is everyone moved from the state where child custody was initially set? Do I still have to go back there? So if they kind of started initiating it and then they moved, where is the whole child custody thing going to have to initially do here?
Yeah, I'll jump in on this one since it related to the one of the tips I gave. So generally, the states have a uniform law that sort of fixes where jurisdiction for custody cases is set, and they first look at the home state for the initial determination. So let's say that's in Oklahoma. Then if the parties and the child move, the question of do the parties have to go back to Oklahoma, or can they go where the child's new residence is, becomes something that has to be analyzed legally. Generally, if the other parent stayed in Oklahoma and that child still goes back and visits, then more likely than not, it's going to be the exclusive jurisdiction is going to be held by Oklahoma. And the parent that moved is going to have to go all the way back to Oklahoma to file for any type of modification or change to custody. On the other hand, let's say if the child custody was set back in Oklahoma when the parties were stationed there, 2 years later, there's an issue that's causing a need to change the custody order, and both parties moved. The spouse moved back to, let's say, Florida, where their family resides. The service member moved to California, where they're now stationed. The child hasn't had any contact in the last 2 years with that original place. Then there's coordination under this uniform statute that has to happen between the original state and the new home state. But generally that the two courts are going to talk about what's the best place. And under the fact pattern I just gave, it's going to be the location where the child has the greatest contacts. Really it's where it's reestablished a home state and where it's most appropriate for the child custody determination to be made now that no one lives back in that, I think I said Oklahoma as the original place. So that's a good question. It's one that don't take this to the bank without having a lawyer look at it, because it is extremely fact intensive, because the whole intent of these uniform statutes is to first have one court and for it to keep it. So there isn't what's called forum shopping, saying, oh, California does this way different, so let me move to California and get a different outcome altogether than the one I got in Oklahoma. They want it to be set by the initial facts, not by people shopping for the best answer and then constantly engaged in litigation, putting the child in jeopardy.
Cassandra, I hope that you took all of that in. Great question. And if you certainly need more information, you can reach out to Mike and Pat, and certainly go to the website, patriotslawgroup.com. Anybody else out there, you can also go to patriotslawgroup.com for more information. I have to tell you, this has been another great session. And for all of our active duty service people out there, our veterans and our military spouses, if you are going through a military divorce and you have been picking up some of the tips and some legal guidance today, and you really need to get more strategies, some more education, and kind of move forward with, somebody to help you through this. I hope this has given you, a little bit of an idea that there are people out there, and people who really understand the ins and outs and can help you navigate this as simply as possible so that you get better outcomes. That's why Pat and Mike are doing, kind of a free service for you. I mean, they're spending their time to help you in a difficult situation. And that's why we are here every other Wednesday. Well, it's kind of, I don't know how this is working. We're doing the second and fourth Wednesday of the month. It's kind of following that way. We're here at 12:30 to 1 Eastern Standard Time. And we really hope you tune in. We have a different topic every single time that we show up. I have to tell you, great news. We are the fastest growing live stream, and we are the only ones offering legal advice in this specific topic. So we know there are a lot of you out there who are in need of this information. And we have a lot of legal professionals tuning in who are wanting to know what is the latest information about this specific topic. And we have two who really are laser focused on knowing that. And so you can be picking up some information if you need to partner with them and help your clients out there. So please reach out to Mike and Pat, who really know the ins and outs of this. So we've gone over a little bit, but I think it's been well worth it. So we will see everybody on the fourth Wednesday of September with a new topic for everybody. And we are out for today. We will look forward to seeing everybody in a couple weeks. All right, everybody.